Nido Gumbo, Your Worship, Northern Sud.
Today it is the 30th of July 2025 in Pretoria North Magistrate Court in the District of North State versus 3 accused persons, Pelia Maeko, Sithole, and Nido Gumbo. They are all in custody. Today's appearances are as follows: Presiding Officer, Honorable Magistrate Ms. Khan, Public Prosecutor Advocate Tumelo Letawana, Cause Interpreter Mr. Nchebe, Stenographer Ms. Matlo Pleasure Maoka. Worship, I confirm my appearance for the state and my readiness to note the court's judgment. All accused persons, they are represented by Ms. Ngwenya. The record will reflect, Worship, that all along Mr. Kekana has always been on record. However, Ms. Ngwenya will be taking over from Mr. Kekana, and if she may confirm my appearance and also her readiness to note the court's judgment.
As the court pleases, Your Worship, I do confirm my appearance on behalf of accused number 1, 2, and 3. I am ready, Your Worship, as the court pleases.
I saw you chewing now.
In the absence of anything further, judgment on bail. On the evening of 10th of May 2024 at 10 p.m. in the township of Soshanguve within the Tshwane district, a tragic incident unfolded outside the home of Mr. Phalane Sr.
Ka letsatsi la di-10 May ngwaga o fetileng ka 10 p.m. Bona ko Soshanguve go ya ba diragala botlhoko mo lelapeng la ntate Phalane.
During a hijacking, 3 assailants sought to steal Mr. Phalane's motor vehicle that he drove in. In the midst of this violent act, the deceased 6-year-old Ditebogo Phalane Jr. unintentionally interrupted the robbery.
Ka letsatsi leo go ya go bonagala gore ntate ba bararo mo leng gore
It called the investigating officer, Sergeant Mashudu Sabasa, who has 17 years of experience and currently is based in the Serious and Violent Crimes Unit.
Bathuthisi baye ba tlisa go ya ka tsamaiso ya case Lipolisa IO ka Sithole ntate wa teng ke ntate Mashudu ke ena detective o tsamaisa case e teng and gape o na le 17 years tsamaisa di cases tse di tshwana le
For the purpose of this bail application, not all of the evidence adduced in this court would be repeated, as it forms part of the record. Reference will be made to certain parts thereof.
Magistrate wa tlhalosa ya gore ya bopaki bo tlile ka moka ka botlalo mo phela proti emba a tlo boeletsa emba gape ge e tsamaisa go ya ka tswetso ya gagwe o tlo tseya mo le mola go tsamaisa tswetso ya gagwe.
In opposing the application, counsel for the state relied on grounds as enlisted in section 60, subsection 4, A to E. The general import of the section is the interest of justice will militate against the release of an accused if any of the listed grounds is proven. The prohibitive grounds are as follows.
Magistrate tsalla pele ya gore mothusisi ka letsatsi la teng o eme mo a dutseng teng tsamaisa case yona kapa kopo ya pele ka matla ganetsa a berekisa molaotheo wa section 6011 B section 4A up to E.
Subsection A, whether there is a likelihood if he or she is released out on bail will endanger the safety of the public or any particular person or will commit a Schedule 1 offense.
Section A, e bua ka gore motho wa teng ge gore o tlo fumana bail e ka ba motho wa teng ge e go hae a se motho mo leng gore o tlo tswella pele go etsa case engwe kapa molato o mongwe hape na mo lebitsong la gagwe.
The evidence by the investigating officer was that after the arrest of accused 1, the complainant, Mr. Phalane Sr., was followed and threatened numerously, which he had reported to the police. He and his family had to relocate for fear of their safety, for their lives.
Magistrate to tlaisa bopaki bo bongwe bo tlileng mo phela court go ya ka tsamaiso ya case ya gore ka letsatsi leo molatofatso wa mathomo e tshwarwa ke mapodisi go ya go diragala gore matsatsi a tlang o mongwe wa molli mo caseng go na le nako le lengwe o ye wa shiswana ke batho mo a tsamayang teng go na le batho a ba mosetse morago.
Subsection B, whether there is a likelihood that the accused, if he or she is released out on bail, will attempt to evade his or her trial. It was not in dispute that the state, through the DPP, has elected to prosecute this matter in the High Court.
Hape e bua ka gore e ka ba motho wa teng o tlo ba teng nako ka moka mo leng gore a tlo gona go tsamaisa case ya gagwe na a tlo thabela molato wa gagwe.
The state
ba una le mabaka mo leng gore a tlile mo pela court ya gore mothutisi o a fiwa matla ya gore case o tlamile a tsamaise case go ya ka matla a DPP.
The state will be relying on common purpose and premeditation in respect of the murder count. Upon conviction, life imprisonment is justicable.
Hape magistrate ba ba tlhalosa bathutisi mo la gore molato o ke molato mo leng gore ke molato ba batho ba nagana ya gore ba tloetsa jwang mo leng gore ka letsatsi la teng go ye go diragala setlo seo se botlhoko mo ngwaneng and hape mo lapeng la bana and gape molato o he gore bathutisi and le khotho e tsaya tswetso ke tswetso mo leng gore batho ba teng ba ya ka mogare o trongo.
The magnitude of the punishment that would be meted out would be a reason for the applicant to evade his trial and flee the country.
And gape ka tsetso eo mothutisi o bona gore molatofatso wa mathomo o tlo thabela yona case.
Subsection C, whether there is a likelihood that the accused, if he or she is released out on bail, will attempt to influence or intimidate witnesses or conceal or destroy evidence.
And gape section C o bua ka gore ge motho wa teng o tlo fumana baile e ka ba bo motho mo e leng gore ge e go hae kwale o tlo leka go tshosetsa batho mo e leng gore go tlamehile gore ba pakele case e ka ba bopaki ba case e a etse ka matla gore bo sa fitlhe mo matsogong ba police.
Sergeant Sabasa testified that the accused before court called themselves the task team. All of them would be armed with firearms and terrorize communities, starting from Soshanguve, Acacia, Magopane, going on to Rustenburg. On the 26th of April 2024 at 8 o'clock, another case was opened in Hebron where the accused shot at the complainant whilst hijacking him. He survived because he shot back.
And the case between
to my mind, this was an obvious attempt to get rid of an eyewitness. I feel it. Sorry. I feel that the applicant's through the applicant's past behavior, there is a likelihood that there would be a concealment or destruction of evidence and intimidation of witnesses. The applicant made several pointing outs. One such pointing out was that of the complainant's canopy, which was sold. He knows the address and the whereabouts of that state witness. Subsection D, whether there is a likelihood that the accused, if he or she were released out on bail, would undermine or jeopardize the objectives of the proper functioning of the criminal justice system, including the bail system. Let's firstly look at the fact that the applicant, on his first appearance, did not disclose his previous conviction of assault, which also has an element of violence in it. He does not appear to be a person who will honor the bail system. Not even stringent conditions will deter him.
Magistrate,
Subsection E, where in the exceptional circumstances there is likelihood that the release of the accused will disturb the public order or undermine the public peace and or security.
and.
5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 5 Sergeant Sabasa testified that he was grateful for the community of Soshanguve for rallying around Mr. Phalane Sr., offering support to the family, and he also mentioned that they had assisted him extensively with his investigations.
And we are
He stated, and the court had taken judicial notice, that the people of Soshanguve were enraged by the killing of young Ditebogo Phalane Jr. There is a strong likelihood that the public order would be undermined as the community may try to take things into their own hands. It has been reiterated in S versus Lupuwana 2015 in respect of exceptional circumstances, and decided in numerous cases that such factors or circumstances need not be rare in the ordinary sense of the word, but should be factors or circumstances which, when cumulatively considered, the court should be persuaded that it would be in the interest of justice to grant bail.
Magistrate,
in determining the existence of exceptional circumstances in the context of Section 6011A, the substantive strength of the prosecution's case was held to be material and a relevant consideration. Sergeant Sabasa thoroughly addressed the substantive merits of the case against the applicant and his co-accused, and now that investigations are complete, he stated the applicant made several pointing outs and further assisted in the arrest of his two co-accused. Both co-accused subsequently made confessions. Items such as cell phones which were taken from complainants were subsequently found in possession of all three accused. All three accused were also found in possession of firearms. One such firearm was taken from a police official who was robbed. Accused 2 was found in possession of the Nissan Qashqai that was robbed from the complainant. He was also found in possession of a car jammer. The gravamen of formidable strength of the respondent's case remained unshaken even through cross-examination of Sergeant Sabasa. Finally, the court would examine the factors that the applicant has proposed as being exceptional circumstances in his case.
Benong magistrate tlamehile a lebelle gore go ya ka kopo ya gagwe ya bail platofatso ya mathomo e ka ba a teng mabaka a utlwahalang na.
The applicant contends that since the death of his brother, he has been financially responsible for his niece.
O tlisitse taba ya gore since ngwana go habo e tlhokofetse ke yena motho mo leng gore o tlhokomela la.
In addition, he has a minor child with his girlfriend, and a second child was born whilst he was incarcerated.
Ene gape ngwana wa gagwe wa bobedi o ile wa ka mo tshwatsile ene gape ka nako eo yena a le go toropong ge e tswaleng.
He states that it would be in the best interest of the minor children that he be released out on bail.
Beanong ka seo gore magistrate tlamehile a lebelle gore eo ke lebaka le le utlwahalang ya gore a fumane bail na.
The evidence clearly shows that the applicant is not the primary caregiver of the minor child, of the minor children, and the minor children would not be destitute.
Ene gape ka bopaki bo botlileng mo pela court a se yena motho mo leng gore o botlhokwa go tlhokomela bana.
I must also take into consideration the best interest of Mr. and Mrs. Phalane and the family and friends of the family and their loved ones.
And the magistrate could tlamehile gore a lebelle ba lelapa la ka Phalane the friends tsa bona le bo botlhe batho a ba utlwisitswe botlhoko go ya ka case yona.
Their best interest far outweighs that of the applicant in the circumstances.
Maemo a bona a botlhokwa go fetisa.
Best interest of the applicant's children is not obsolete and may not simply override all other legitimate interests, such as the interest of the public and the interest of justice.
Maemo a tlisitsweng go platofatso ya mathomo ai maemo a gagwe a wana matla go fetisa maemo a tlileng mo pela gagwe go ya gape le maemo mo leng gore a molato a lebellane le wona.
The second factor is that he is a businessman. He owns a salon and also conducts children to school.
Hape bopaki a bo tlisitseng mo pela court he go ya ka maemo a utlwahalang go gore yena ke businessman ene gape o tsamaisa bana go ba sa sekolong.
He claims his employment and business would suffer. I totally disagree. Loss of employment is a natural and inevitable consequence of incarceration and not an exceptional circumstance.
Ene gape magistrate o utlwile ge a re le business ya gagwe ya salon ga e kwale o tore mo leng gore e ka mogare a nna mo leng gore batho ba tlo kgona o fumana business o kapa a kgone business ya gagwe o tswelela pele. Magistrate o re seo ke ntho e tlwaelegileng mo leng gore business o kgona go fela and business o kgona gape e be teng mare ntho a se ntho mo leng gore a no e tlisa mo pela court a re business ya gagwe e tlo safala.
The third factor that he has advanced is that his mother has arthritis and walks with crutches. This aspect was thoroughly investigated by Sergeant Sabasa.
Sergeant Sabasa o tswelle pele go ya ka bopaki bo bodileng ka molatofatso wa mathomo ya gore mme wa gagwe o na le arthritis ka le hape o berekisa di-crutches go tsamaya. O ya ba tswella pele go ya ka bopaki.
It was his evidence that the applicant's mother had lived alone since she came from Limpopo for her son's funeral, and the accused had never stayed with her.
O tlhalosa go ya ka mme o ya gore mme o kgale e teng le nako la bolupo la ngwana wa gagwe mme na le teng empa molatofatswa a bona nako mo leng gore o ye wa bonagala go bophelo ba bona.
She had also told Sergeant Sabasa that if she needed anyone's assistance, she would ask her deceased son's friend, Simon Glamini, who had on various occasions assisted her.
Hape go ya ka mme ge boa le ntate SABC o ya go tlhalosetse gobane ge ke batla thuso ke tlo kopela mogwera wa mofi ke yena Simon Dlamini hobane ke yena motho a nthusang.
The clinic was not far from her house. In fact, it was walking distance, and she did not need anyone to assist. And if she did indeed need anyone to assist her, she would get somebody from Limpopo.
And look at the clinic. Who haufi. And the hore ebe batla go ya clinic, kampane a kupele motho wa go Limpopo gore a tle a tlo mo thusa.
In conclusion, the court finds that the applicant had failed to discharge the onus that rests on him of establishing on a balance of probabilities that exceptional circumstances exist which warrant his release out on bail.
Go ya ka moka a bopaki bo butileng mo pela court magistrate o tseya tshwetso ya gore go ya ka kopo ya molatofatsa wa mathomo molatofatsa a gona bopaki kapa maemo a utlwagalang mo leng gore maemo a teng a tlo fa ditla gore magistrate a mo fe bail.
Bail is denied. The applicant will remain in custody until the matter is finalized in court.
Magistrate o tseya tshwetso ya gore o ganetsa bail mo lebitsong la gagwe o tlo nna ka mo gare go tronkong go fitlhella molato o ya Pretoria.
That's the court decision. Worship, I have the privilege to liaise with the deputies of this today, who informs that the indictment is not ready. However, they're still working on it. When I inquired about the time frame, it's at 3 to 4 weeks. May I suggest the 10th of September 2025 for indictments.
Thank you, suitable for the debate, Your Worship.
Thank you so much. Okay, all three accused, the state,
Melamo.
your attorney will explain to you what an indictment is. That will be served on you all on the next appearance. I will, of course, explain to you everything that you have to do before you reach the High Court. Do you all understand that?
Magistrate wa tlhalosa gore mmueledi wa lona o tlo tlhalosetse go ya ka indictment ke eng empa ne tlo fumana tlhaloso eo ge ne tlo fumana letsatsi mo leng gore jaanong molato wa lona a sewe for high.
All three accused, matter is being postponed to the 10th of September in order for the state to serve each accused with the indictment. All three accused will remain in custody until then.
September ngwaga o re mo ona mo kotsi first aid mo lo gore ni tlo tsebiswa ya gore case ya lena e se waneng date ke di 10th of September ni tlo boela
Yes.
May I kindly ask that you adjourn for a short adjournment up until 10 to 12?
It's a short adjournment. 10 to 12, everyone, for a short adjournment.
It's okay.